grant the motion, find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to all right, court is calling 2023 CR 10986, State of Texas versus Leslie Myers.
Leslie Myers came into Judge Stephanie Boyd's courtroom expecting a 2-year agreement after violating her probation, but the judge quickly realized something important. This wasn't just another violation. The same person involved in her original family violence case was now involved again. After hearing both sides, Judge Boyd rejected the recommendation and delivered a much tougher sentence.
Could I have parties announced for the record? For the state.
Alexandria Bogus for the state.
Defense.
George Schaefer for defendant, Your Honor.
And are you Leslie Myers?
Yes, Your Honor.
And am I pronouncing your last name correctly?
Yes, thank you.
Sure. Did you review, just one moment. All right. Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Leslie Dawn Myers who was placed on deferred adjudication in 2023 CR 10986 for the offense of assault, family second offense on December 13, 2023 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state.
Violating condition number 24B on or about the 15th day of November 2024 in Bexar County, Texas. The defendant, Leslie Dawn Myers, did then and there find herself in contact with Benjamin Guild and threatened, assaulted, or verbally abused said person in violation of condition number 24B.
To that, how do you plea? True or not true?
True, Your Honor.
The state waives the remaining allegations, Your Honor.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of 24B, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to proceed with your plea of true to 24B?
Yes, Your Honor.
Court will find 24B true. All right. Is there a proposed agreement?
There is, Your Honor. The proposed agreement is that she be sentenced to 2 years TDC.
All right. So has she done anything on probation other than threatening someone?
She said a bunch of negative UAs, Judge.
I finished my 5th class as well, and I did my 90 and 90, and I did about 3 or 4 meetings weekly. I was about to start my community service.
All right. And Benjamin
Guild.
Is he the complainant in this case?
He is, Your Honor. And he's present in the courtroom.
All right. Does anybody want to call him as a witness? Because I don't think that, okay. I don't think that 2 years is appropriate in this case. And let me explain to everybody why. It's because she's on probation for assault against the complainant. And then 24B is, I don't know, assaultive language or threats against the same complainant. So I don't understand why it should follow the agreement. That's what I'm asking.
Judge, I'll call him as a witness.
All right. Mr. Gill, if you can come forward, please. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Benjamin Holmes Guild.
All right, defense.
And you are the same person who was the complainant in the original case that she was put on probation for?
Yes.
And you are the same person who has alleged that on November the 15th of 2024, she committed another assault against you, correct? Now, at the time, were y'all drinking alcohol? She's not supposed to consume alcohol. You're aware of that, correct? Same thing with you. You're not supposed to consume alcohol. And that's because you're on a probation yourself. And what was the nature and extent of this argument? What happened?
I'm not sure of the details, to be honest. Call the details.
Okay. You were arguing with her?
It's probably mutual.
She was arguing with you?
No, it was probably more me than.
You understand that the state is recommending a sentence of 2 years. Are you amenable to that, or would you accept that?
Define amenable.
Well, are you happier than the court saying, no, I'm not going to accept that offer and sentence her up to 10 years?
I would rather that not happen. I'd rather she get less than 2 years.
How long have you and she been together?
On and off for. She's been down here for 8 years. We've been acquaintances for 20 years, 20 plus years, 25 years.
And I'll pass the witness.
All right, any questions?
I have no questions.
All right, thank you. All right. This is, if there's nothing else from either side, this is what the court is going to do. Court is finding
24B.
24B true. The court will grant the motion. The court will find you guilty, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Benjamin Gill. I'll request the therapeutic community for you, and the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, this is not a plea bargain agreement. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Do you understand? Right. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Leslie Myers walked into court facing a possible second chance, but Judge Stephanie Boyd saw a much bigger problem than just one probation violation. Myers was already on deferred adjudication for a serious family violence offense. The purpose of probation was to give her an opportunity to prove she could follow the rules and avoid returning to the same behavior. But according to the court, that opportunity was put at risk when she violated one of the most important conditions of her supervision by having contact with the same complainant connected to her original case. While the state and defense suggested a 2-year sentence, Judge Boyd questioned whether that punishment truly reflected the seriousness of what happened. The judge pointed out that this was not a random violation involving a different person. It involved the same individual from the original assault case, making the situation much more concerning. After listening to testimony and reviewing the circumstances, Judge Boyd made her decision. The 2-year recommendation was rejected. Leslie Myers was sentenced to 4 years in prison. The court also entered an affirmative finding of family violence, ordered no contact with the complainant, and reminded her that future choices would have serious consequences. This hearing showed one important message from Judge Boyd's courtroom. Probation is not freedom without responsibility. It is an opportunity, and when that opportunity is broken, the consequences can become much more severe.
2020 CR 9618 State versus Ricky Thatcher. Could I have parties announced?
Megan Galloway for the state.
Nick Aguilera on behalf of the Honorable Ricky Thatcher.
On the indictment as presented.
No, Your Honor, we are waiving the repeater enhancement and the deadly weapon allegation and count 1. We are proceeding on count 2, but we have a motion to proceed on the lesser included offense of possession of a controlled substance, PG1, 200 to 400 grams. And then we are proceeding on counts 3 and 4 as is.
And count 2. The state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, 200 grams to 400 grams. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Count 3 is evading arrest detention with a vehicle. Count 4 is felon in possession of a firearm. Those are third-degree felonies. Range of punishment for each of those is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Mr. Thatcher, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on counts 2, 3, and 4. They're proceeding on the lesser included offense in count 2 of possession of a controlled substance, penalty group 1, 200 grams to 400 grams. Punishment is to be assessed at 8 years in the prison. There's a $2,000 fine. There are no applications, and the state will take in consideration 2025 CC 009785. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Then to count two, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count three, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count four, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's plea.
State offers states one in attachments.
And for the purpose of this plea, Judge, we have no objection.
All right, State, you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Objection.
Thank you. Oh, I think this is a county court.
Take it. I thought they handed it to me to hand to you.
All right, no problem. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of counts 2, 3, and 4, and the court will find you guilty of counts 2, 3, and 4. Are you proceeding with sentencing?
You would consider considering going straight to punishment, Judge. There's no application. We're not applying. We know we're going to TDC. Would have you to consider the recommendation of 8-year TDC.
All right. This is what the court will do. And count 2, the court will sentence you to 8 years in the prison. And as previously stated, the court is finding you guilty of counts 2, 3, and 4. And counts 3, the court will sentence you to 8 years in the prison. Count 4, the court would sentence you to 8 years in the prison. Counts 2, counts 3, and counts 4 are running concurrently, and legally they have to run concurrently
Yes, sir.
for any time served. Take in consideration 2025 CC 009785. There's to be a $2,000 fine, and there's to be no contact with minors.
Your Honor.
All right, we can go off the record. Here's the thing. You have some decisions to make about your life. You understand?
Yes, ma'am.
Only 1 or 2 things will happen in the business that you're in. Number 1, the money that you make, that's the fast money. I bet you don't even know where it went,
It's not worth.
and it's not worth it. And because when you do this, you are building your happiness off someone else's misery, and that's never a good thing to do. Do you understand?
Sure.
All right, good luck to you.